Hey Nick, how you doing?
I'm good and you.
Good, good, good.
Good. So another episode of PLA. I'm going to ask you the first question today, and we're continuing on our questions with regards to student leases and our information session on that. So last week when we talked about our student leases, we talked about a little bit about internal structuring and how people need to approach student leases. What structure should they use? We're going to continue on that trend today, but instead of talking about internal structuring, I'd like to ask you to just touch a little bit on external structuring. So,
Sure.
if you are going to move into this sort of deal and you're going to do it with other people, have business relationships in a student accommodation field, how should you look at that structuring to make sure that you're protected?
So when dealing with the question of finance and how to raise money, how to raise capital, how to raise debt, the first question that needs to be asked is what is the difference between equity and debt? Before we're able to have a discussion around the structuring behind involving third parties in any business transaction whatsoever, we have to ask ourselves first, what's the difference between equity and debt, and which one do we want for our business? Now, equity is normally when you involve someone as a shareholder, as an example, to your business, somebody that shares in the upside but may share on in the downside also. So somebody that takes risk in the business versus debt, as an example, that's a contractual arrangement where somebody lends something to you, you borrow, and you have to repay whatever the person borrows. Now, obviously, it's not always as simple as that because equity comes in many shapes and forms. And some equity can actually look like debt, as an example. Some equity can carry less upside, can carry less downside. So please bear in mind that there is no simple answer to what is equity. And if a person comes in, they get 50% of my business, that's not necessarily the case. But you need to understand that the dynamic and the stark differences between equity and debt is that one involves somebody else in your business where they carry risk and get an upside versus the other, a lender that in theory should not have a downside because they are guaranteed contractually, that is, to get their money back and they will receive their returns by way of interest. And their returns are again often guaranteed in the contract. There is no variable, but as I mentioned before, these terms can actually be adjusted. So when it comes to equity, let's focus a little bit on equity this time around. So when I want to involve somebody in my business, but I don't want to take out a debt just in case something goes wrong and I don't want to carry that risk. So I'm happy to involve someone. So let's say, for example, they're willing to contribute capital, so money towards the deal. Maybe they're willing to use their money to buy the property while you operate the deal. Or maybe both of you are contributing money to buy this property. The first the first thing that we need to look at in this equity conversation is there's a difference between somebody coming in as a shareholder and somebody coming in as a JV partner, right? These are two different things. They might look the same, and yes, shareholding has a component of joint venturing in it. But if you try distinguish between the two, joint venture can be an agreement or a contract between you and the other person. It doesn't have to be an equity stake. It could even be a services arrangement. So two people come together and they decide that they are going to embark on a development, as an example. And they decide just for this project that they're going to put their resources together. Maybe one person contributes the property, the other person contributes the skill in the construction. They build out this property, they sell it, and they share in the profits. Now, that doesn't necessarily mean that there was an equity stake or a shareholding. It was a joint venture for that particular property or that particular business. And this happens very, very often. So, for example, you may find that two service providers can work hand in hand. They've got an agreement between each other that they go out, they try and get clients, and whoever gets clients is able to refer that business to the other one also. So many people work hand in hand when it comes to these sort of arrangements. But that does not mean that they have equity in each other's businesses. They simply work together in order to drive a very common purpose and a very common goal. Now, shareholding, on the other hand, is when somebody is involved in your business. They've actually got a shareholding in the business. And that's normally when we speak about shareholders agreements and company structures and memorandums of incorporation. That's normally what we need to look at, because the JV agreement, again, is based very much on performance. It's working together together in a contract that specifies this is what you're going to do, this is what I'm going to do, and once the money comes in, we will divide it equally. And that goes back to the development example, where one person can contribute something, the other something else, and they just share the profits at the end. Now, when it comes to shareholder agreements, that is very, very different, because remember, shareholder agreements can go in different directions. So you can have multiple shareholders that invest in a company, and they are investing. So the first question, or the first thing to look at, is the start of the business, and that's normally the ownership. So now they go in, they buy shares. You need to know what they're contributing and what they're getting in return. So that's very, very important. Who's putting in what and what are they receiving? And remember that it's not just about money. A person doesn't have to put in capital to receive shares. A person can also perform services. If you're an expert in your field and you're able, again, going back to the development example, if you've got the construction knowledge to be able to project manage the development, and all you need to do is raise capital in order to pay for the cost of the development, you can very easily negotiate a 50% stake in the deal, or a 40% or a 30%. This is all subject to negotiation, but it has to be clear from day one. Who is putting in what, and what does this actually buy them? So that's question number one. And one little thing, a little side note to that. Remember that a lot of people nowadays anticipate that when they put capital into a business, that they actually receive that capital back as a repayment of a loan. So please be very careful with this, because if a person's lending money to the business, getting equity stake, and then demanding a repayment of a loan, then in theory, they didn't contribute capital. So just be careful, because that catches a lot of people by surprise. Now, the second part of this is the operational part, the control part. Now, a shareholder putting in money, as an example, would want to understand what level of control he has over the operation of this business. If it's a development where two people in a company are developing a property together, or student accommodation where they're buying property and they're letting it out, the one person wants to have an understanding, how is this business going to run? Who is responsible for hiring letting agents, or for attending the vetting themselves, or for undertaking certain repairs, and for tenant engagement, for the installation of security? So there's certain functions that are normally undertaken by what we call a board of directors. So this is the operational engine of any company. It's the board of directors. From the beginning, we need to establish what this board is supposed to look like. Who sits at the head of the board, normally as a CEO, and how are decisions made? And remember, there's certain levels of decisions. So certain decisions can be made directly by the CEO without question or without having to ask anyone else. Certain decisions should actually be made by the board, which is a combined effort where a number of directors would make a decision. And this is often where you find that some shareholders sit on the board of directors in order to make some very important decisions. And with smaller companies, what you actually find is shareholders reserve some decisions for themselves. And that's important, like changing the memorandum of incorporation is a big thing, or selling all the assets in the business. It's a big thing. So these are normally reserved for the shareholders. Now, we don't like giving too much to the shareholders to make decisions over, because if something were to happen and a shareholder passes away, they're not easily substitutable, whereas directors are. So the lion's share of the decisions should sit with the directors. And lastly, it's the exit. And this in itself is a conversation I could have for many, many hours. But what is the exit? When does the company dispose of its assets? When does the shareholder sell their shares? How does the shareholder sell their shares? Are they obligated to give it to the other shareholders first, or can they go out to market and sell? Is there a restriction on who they can sell to? Is there a provision in the contract that actually compels them to sell shares back to the company upon a certain date? Because this happens very frequently, where you can be a shareholder for 5 years, but on year 5, if the company opts to buy the shares back, they can exercise an option to do so. And there's even other little intricate clauses. For example, if one person wants to buy out 100% of the company and you have a small little minority shareholder, you can also agree ahead of time that that minority shareholder may be forced to sell their shares in that event. So these are things like drag along, tag along clauses. So you need to understand that you have to have these conversations as you negotiate the business relationship with these third parties. If you are entering into an agreement or a company setup with other shareholders, and where the conversation needs to be around what the person's receiving, how the company is operating, and where it all ends.
Absolutely. Thank you for that, Bruno.